Hi, I'm Brian Chase, Director of Digital Forensics here at Archer Hall. And today I want to talk to you about law enforcement's ability to compel a suspect to give up a password to their phone or to their computer. So the Fifth Amendment protects the right of individuals to be a witness against themselves, meaning a witness cannot be forced to testify against themselves. Courts have held that giving up something you know, such as a password, is protected by the Fifth Amendment. So courts generally find that law enforcement is unable to force a suspect to give up their password to their phone or their computer. But then the question comes, what about using fingerprint to unlock your phone or Face ID? Here, courts are divided. Most courts find that giving up a fingerprint or Face ID is not protected by the Fifth Amendment because it's not something that's the contents of your mind, it's a physical characteristic. Courts have long held that suspects can be required to give up fingerprints in order to match them to fingerprints found at a scene, give up blood samples, give up voice exemplars. So many courts have found that using a fingerprint or Face ID to unlock a phone is just like those prior examples where the court said that law enforcement can compel a suspect to do it. Some courts have taken a different approach and found that giving up a fingerprint is no different in effect than giving up a password. That an individual who chooses to lock their phone with their fingerprint shouldn't be afforded less protection under the Fifth Amendment than an individual who chooses to who chooses to lock their phone with a password. There is one exception to this rule about giving up passwords, and that's called the foregone conclusion exception. Under the foregone conclusion exception, if law enforcement can demonstrate that they have knowledge of the existence of the evidence they are seeking, that the defendant possesses or controls that evidence, and that they have knowledge of the authenticity of that evidence, then the actual unlocking of the phone is just going to reveal evidence that is a foregone conclusion because law enforcement already knows of the existence. When there's a foregone conclusion, then the Fifth Amendment rights are not reached. So a defendant can be forced to give up their password if law enforcement can demonstrate that they already know what's going to be on that device. In a modern example of this situation, there is a suspect being charged with child pornography. Law enforcement had looked at his computer, found signs of child pornography, and had found signs that an external hard drive had been connected to his computer. But that external hard drive was encrypted. Law enforcement found a witness who said that she saw child pornography on that external hard drive. And when they questioned the defendant about it, about giving up his password, he told law enforcement, "We both know what will happen if I give you that password." Law enforcement went to the court, asked for a warrant forcing the defendant to give up the password. They argued the foregone conclusion, and they won. The case went up to the Court of Appeals, and the Court of Appeals agreed with the government that it was a foregone conclusion. The government had established that they knew what was going to be on the drive. They established that the defendant had control of that drive, and they established that that drive had been connected to a computer that was in the defendant's possession. And in that situation, the defendant was ordered to give up his password. But in the vast majority of circumstances, law enforcement is unable to force an individual to give up their password to their phone or to their computer. But depending on your jurisdiction, they may be able to force you to give up your fingerprint or use Face ID to unlock your phone. Thanks for watching. We hope you found this useful. And if you're dealing with a case involving the unlocking of a phone or a computer, please feel free to call us. We'd be happy to assist you. Thanks.